Hello, welcome to another edition of Matters of Law. Matters of Law, the law reigns supreme. I hope you enjoyed our session on applying for letters of administration. Let's go for a spot of commercial. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097. 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. Today we are discussing execution processes in civil cases. Execution processes in civil cases. Well, I know somebody is wondering, the word execution, does it mean we are going to kill anybody? No, definitely we are not talking about killing somebody. But whenever you go to court for a judgment in a civil case, cases between individuals, cases which are not criminal, there are processes that you have to take to ensure that the benefits of the judgment accrue to you, or you get the benefit of a judgment. For example, if you take a debt recovery matter, or you take somebody owes you and take the person to court, and judgment is given in your favor, how you recover that amount of money, or how you will get that your money back, you have to take certain steps. So the fact that you have gotten judgment doesn't mean automatically that you get your money back. You have to go through what we call the execution processes. So when you are in a civil case and judgment is given, you are required to do what we call entry of judgment. Now, if your case was before the district court, you will be entering what we call the formal decree. That is letting the other party who has lost know that this is the judgment that was given by the court. It doesn't matter whether the person was in court or not. You have to serve that process. So we'll call, for circuit court and the high court, we call that entry of judgment. And for the district court, we call that a formal decree. That should include every cost that was awarded against the person during the pendency of the civil action. It should also include exactly what the court decided on and the orders given by the court. Once you file that process, it has to be served by the court bailiffs on the other party who is the losing party. The person has to be notified before you take any steps to execute your judgment. So, for example, if somebody owes you, one of the steps you can take is ask for garnishee proceedings. The word garnishee, what does it mean? It just simply means that you file a process with the bank account or the bank details or any financial institution which has money belonging to the person who has lost the judgment. Once you're able to retrieve the person's bank account number, the branch of the bank, you file, or with the help of your lawyers, you file the garnishee proceedings. Now, when they file the garnishee proceedings, the financial institution, usually being the banks, are required to appear before the court on a named date. Now, when they appear before the court on that named date, they come and disclose to the bank whether there's any money standing to the credit of the person who lost the judgment. If there's any money standing to the credit, they will declare the amount of money standing to the credit of that person, or amount of money in the account. Then the judge is most likely going to grant what we call garnishee order nisi. Simply meaning that they are not to touch anything, they are not to take any money out of their accounts. So the account is, for want of better expression, they will be frozen until the court takes a final decision, a final determination, which is called the garnishee order absolute. Now, in respect of the garnishee order absolute, the court will hear the parties and ensure that the amount of money standing to the credit of that person is used to pay the judgment debt. If that amount of money is not enough, then the court will decide what next step to take. But ordinarily, whatever is in the account standing to the credit of the person who has lost the judgment would be asked to be credited to the judgment creditor. Now, that's the one who has won the case. Now, what if the person doesn't have any money in any bank accounts or anything like that? One of the things you need to know is that before you even take anybody to court, you should ask yourself, when judgment is given to me, how will I execute the judgment? Can I get the said property? So in the case where the person doesn't have any money, where you can go by garnishee proceedings, The other option that is available to you is FIFA, the rate of FIFA. Now FIFA simply means that you would go for the item of the person, be it a movable property, tables, chairs, TV, any movable property of the person. You will go and lay claim to that particular property, but you file a process. That process seeks to attach those documents, and as I said, with the help of your lawyers, once you file that process, the court will look at it and ask whether it is just and right for that property to be attached. If the court is of the view that that property has to be attached or can be attached, what the court will do is that they will give an order, and usually you would have to notify the registrar, and with the help of some police officers, you can go and attach those properties or bring those properties to the presence of the court for the purpose of being sold. You don't take it personally and you keep it yourself. So there will be auctioneers involved. The auctioneers will come and sell the said property, be it a house or any other property that they have been able to attach. So it's not only movable property, it may also be immovable property, maybe a house or a land or anything like that. Then they will come and do the auction process. They will look at the value that they will get from it. Once they do the valuation and any money accrues, then they would pay it to the credit of the person we call the judgment creditor. So what if the court has given a judgment to you and has asked that you have a right to repossess land? What do? The steps you take, as I mentioned earlier, is to enter judgment. Now when you enter judgment or file the entry of judgment, the next thing you do is to apply for a writ of possession. A writ of possession is a document from the court that allows you to simply say that yes, you are entering into possession or taking over a particular place. The court will not give any judgment asking that any property on the said land be demolished. If you choose that any property on the said land be demolished, it is at your own expense and your own cost. But remember, before you take any steps, you should have been sure that the judgment clearly has given you possession and you have applied for a writ of possession. It is not the duty of the court to go and destroy anything on any land. That's one of the key things you need to have at the back of your mind. Despite all these processes that I've talked about, even after judgment, the parties to the judgment or the parties to the case can decide to do a settlement outside what the court has agreed on. Yes, you are allowed to do it. But remember, once you do any settlement outside the court's agreement, you are bound by whatever agreement that you have entered into with the party on the other side. So what if it is an injunction that the court has given? Usually we refer to sometimes perpetual injunction. So restricting somebody from going into a particular land, entering a particular house, or going to a particular business. So what if there's an injunction and the one who has lost the case has failed to comply with the court orders and has gone onto the land and is doing things which the court says he or she shouldn't do? What you do in that particular circumstance with your lawyer is to apply for contempt. Contempt of court. So you would have heard of the name contempt of court, and it varied places. In law, we say contempt of court is a quasi-criminal matter, simply meaning that it's likely that the person who is found to be in contempt can't be imprisoned because of the person's acts. Remember, in civil cases, we don't put people in prison. However, if you disobey court orders and you are found to be in contempt, you can be put in prison or you can be fined. Now, if you file a contempt application, the contempt application has to be served on the people who you claim have violated the court order. But if you remember that before you file any contempt application, you should have been sure that the orders of the court were served to the party who is alleged to have been breaching the court orders. And that person should have actual knowledge of the orders of the court. That means the person should have been served with the court process, indicating that the person is injuncted from entering the land or doing anything in respect of any particular property. Once you file the contempt application, they are supposed to be served. And when they are served with the application, every contempt application goes with an affidavit stating the basis by which reason or basis on which you want somebody to be brought before the court for contempt. Once the application is filed, it is served on the parties who are supposed to receive SIP, ensure that the application is served on them. And the day that is fixed for them for the application to be heard, they are supposed to come to court. Now, when they come before the court, because it's what we call a quasi-criminal matter, when the case is called, there's a box in the court where they are supposed to enter, and they will have to stand. That's the requirement of the law. Now, if they receive that application, with the help of their lawyers, they can also respond to the application by filing an affidavit in opposition if they are opposed. If they are not opposed to it and they admit that indeed they have been in contempt of court, what they are required to do is to come and plead before the court, or to do what we call purging of contempt. So whatever they were supposed to do that they did not do, they'll come to the court and say that yes, we were supposed to do A, B, C, D, we have not done it. We are now taking steps to do it, or we are doing so. The court may decide to fine them, or the court may decide, if the court is of the opinion that they have committed contempt, then the court will send them to jail for that contempt that they have committed against the court. At this point, I want to speak a little bit more on contempt. It is not only when you have decided to refuse a judgment of the court or an order of the court. If you disobey courts in open court, or you do anything to bring the administration of justice into disrepute, you can also be cited for contempt, and the court will hear it. And if the court is of the opinion that you are indeed at fault, the court will come after you. We must understand that even throughout the process of execution, a party who is not satisfied with the court decision, or who has suffered the court decision, can apply or can appeal against the decision. Now, appeal against the decision in civil cases, you have a time limit of 3 months to appeal against the decision. If you are not able to appeal against the decision within 3 months, then you have another 3 months to apply for an extension of time within which to appeal against the decision of the court. With the help of your lawyers, they will guide you in all of this. But before you do all of this, you obviously need the proceedings of the court. You need to apply for the proceedings of the court. You need to apply for the judgment and find out whether the judge had made any mistake in law, or the judge had said anything which, according to the evidence that has been led, was not exactly what the position was. And depending on the court you are coming from, you may decide to appeal to a higher court. So if the matter is from the High Court or the Circuit Court, it goes on appeal to the Court of Appeal. If the matter is from the District Court, then you appeal to the High Court. Remember, you need to apply for the proceedings, and you need to apply for the judgment in the case to study and find out whether the judge has made, or the magistrate has made, any mistake in law, or misrepresented a particular fact that was led in the evidence that was before the case. Going to court is not an easy assignment. So before you go to court, you should have been prepared with all the necessary documents that you need to be able to present your case. Indeed, sometimes matters go on appeal and fresh issues based on the law come up. And at the Court of Appeal, that is where the 3 wise men, or if they are women, we call the 3 wise women, will decide on the matter. So at the Circuit Court or the High Court, you have only 1 judge deciding on it. But at the Court of Appeal, we have 3 judges who are deciding on it. If the Court of Appeal gives a decision you are not satisfied with, you can appeal to the Supreme Court. Now, whilst you are applying for appeal, or whilst you are appealing against the decision, it doesn't mean that the judgment the court has given cannot be implemented or cannot be executed. In such a case, what you are required to do under the law is to apply for stay of execution. Stay of execution simply means that don't go ahead with implementing the judgment of the court. If you make that application for stay of execution and it's granted, then you are allowed to hold on till the appeal is decided. In all of these cases, whatever process that you get, you have to make sure that the lawyers are in the know and you do what is right. Thank you for staying with us, and thank you for watching this particular edition on executing civil judgment. We talk about how to obtain the judgment. We talk about how you can execute your judgment by making sure you have entered judgment or a formal decree in case of the district court. You can file garnishee proceedings for recovery of debt. You can also do writ of fife for getting any property that you are entitled to, or payment of any monies to you. You can also file contempt application if a person has refused to obey court orders when it's got to do with injunctions, and also give the timelines within which a person can appeal against the decision of a court to any of the appellate courts. Join us same time next week on Matters of Law. On Matters of Law, we say the law reigns supreme.
To support this program, contact XTV on 024 606 1095 or 050 836 4159, or send us an email to info@stvgh.com.